is punished properly for the abhorrent crime he committed, and I'll join her in that fight every step of the way.
I call the Solicitor General, Michael Tomlinson. I will have to interrupt him in about 1 minute to move the adjournment again. Solicitor General.
Thank you, Madam Deputy Speaker, and thank you for the warning. And I also thank my honourable friend for securing this very important debate. And I particularly thank him for raising the very difficult case of his constituent Charlotte, who was tragically killed by the abhorrent driving of John Owen whilst she was walking on the pavement, a place where she was entitled to feel safe. I pay tribute to the family of Charlotte, and particularly to Charlotte's mother, Claire Reynolds, and I agree with my honourable friend. She has shown unwavering bravery and conviction in the fight for justice. Madam Speaker, driving dangerously and under the influence of drink and drugs is a most serious offence which is resoundingly condemned by all in this House. I want to pick up on some of the specific points that my honourable friend made, but before I do so, let me set out some of the general principles of the unduly lenient sentences known as the ULS scheme. Madam Deputy Speaker, my role...
Order.
I beg to move this House to now adjourn.
The question is this House do now adjourn so we can resume the debate. Solicitor General.
My role, and that of the Attorney, is to act as guardians of the public interest. In exercising our functions, we act quasi-judicially in the public interest and independently of government. I share my honourable friend's desire to ensure that those responsible for terrible crimes are properly punished. In the vast majority of cases, sentencing judges get it right. They deal with a huge variety of cases that vary in complexity and severity, and I take the opportunity to commend them for their work. Thousands of cases are dealt with in the Crown Court each year, and a similar number of sentences imposed. In 2021, 151 cases were referred to the Court of Appeal under the ULS scheme, and sentences were increased in 106 cases. That's a rate of 70%. The ULS scheme, as my honourable friend mentioned, has the intention of promoting justice, fairness and consistency. It allows sentences which are too low to be increased, and they are there to correct an error where judges get it wrong. However, they can only be referred to the Court of Appeal in the following three cases, and if all three are satisfied. Firstly, that the offence is within the ULS scheme. Secondly, that the application is lodged within 28 days. And thirdly, if it appears to the attorney or I that the sentence is not just lenient, but unduly lenient. Of course, not all offences come within the scheme. It's reserved for those offences that are the most serious, such as murder, rape, robbery, and causing death by dangerous driving. It has been extended over recent years. Let me turn now specifically to the offence of causing death by dangerous driving and pick up some of the more specific points that my honourable friend has mentioned. Firstly, his important point about a discount for a guilty plea. Sentencing Council guidelines rightly encourage a defendant to accept responsibility and to avoid the need for a trial. If there was no reduction for a guilty plea, there would be little incentive to plead guilty, and a defendant may as well just have a trial. This would cause more anxiety to witnesses, to victims, and to their families, and it would act as a disincentive to pleading guilty. But we must get the balance right. Hence, there is a process to encourage an early guilty plea. As my honourable friend has said, the reduction is applied on a sliding scale from 1/3, with the largest discounts for cases where a defendant pleads guilty at the early opportunity. And I heard loud and clear what my honourable friend said, and I know that his campaign on this point will continue, but there may be occasions where the first opportunity legally is not the very first appearance in court and may occur later on in proceedings. My honourable friend has also asked specifically about when a case can be referred to the Court of Appeal, and it's important to note, as he rightly has said, that the ULS scheme only applies to sentences that are unduly lenient and not sentences that are simply lenient. The test is a high one. Parliament intended that the Court of Appeal will only grant permission to refer a sentence in exceptional circumstances. As he said, for example, if the judge has passed a sentence that falls outside the range of sentences which a judge could properly consider appropriate, or if there has been a gross error in law. I must mention here and pay tribute to the invaluable work of the Sentencing Council, for its development of sentencing guidelines which assist judges in deciding just and proportionate sentences. And turning to those guidelines, again, my friend quite rightly did so. Firstly, in terms of categorisation, he's right. Level 1 is for the most serious offences, and it encompasses driving that involves a deliberate decision to ignore or a flagrant disregard for the rules of the road. Level 2 is less serious, and it's for driving that has created a substantial risk of danger. Secondly, and as my honourable friend has already said, for an offence importantly committed before the 28th of June of this year, the starting point for a level 1 offence is 8 years in custody with a range of 7 to 14 years. Again, as my honourable friend has quite rightly mentioned, aggravating and mitigating factors must be considered. Once a provisional sentence is arrived at, the court is required to take into account factors that may make an offence more serious, and that is quite right. They're called aggravating features. But it must also consider factors which may reduce the seriousness of the offence or reflect personal mitigation. Those are mitigating factors. And different aggravating and mitigating factors will apply in every case, and it's for the court to decide what weight to place on those sentences. Again, my honourable friend has quite rightly said that sentences for the very top end of the scale are reserved for particularly egregious offences. And Madam Deputy Speaker, I do look at the guidelines themselves. My honourable friend quite fairly mentioned some of the particular factors that are aggravating. Previous convictions for motoring offences. More than one person killed as a result of the offence. Madam Deputy Speaker, every death on the road is a tragedy. But there is a scale, and it is right that where more than one death occurs, that is reflected in the sentence, and that is an aggravating feature. Serious injury to one or more victims, and I'll mention just two more. Other offences that are committed at the same time, such as driving without a licence. And finally, driving off in an attempt to avoid detection or apprehension. And I'm very grateful to my honourable friend for his kind words about our constructive meeting on some of these detailed points. In terms of recent reforms, our laws must strongly signal that causing death by dangerous driving will not be tolerated. Recognising a trend of inadequate sentences for causing death by dangerous driving, I know my honourable friend warmly welcomed and fully supported the Police Crimes Sentencing and Courts Act 2022. He rightly said that increases the maximum sentence from 14 years imprisonment to life imprisonment. Of course, that is only for offences committed after the 28th of June when the Act comes into force. And again, he's absolutely right. That cannot be made retrospectively. I know that my honourable friend is committed to tackling drivers under the influence of alcohol and drugs and for ensuring that all such drivers are caught and punished. The government is too. Firstly, we have increased the maximum penalties for causing death by careless driving when under the influence of drink or drugs. Secondly, we've changed the law to increase both the maximum period of imprisonment and the minimum driver disqualification period for those that commit the most serious road traffic offences, ensuring that they're kept off our roads for a longer period. And I know that my honourable friend is also aware of the Department of Transport's call for evidence relating to drug driving, and that this consultation, or the call for evidence rather, closed in June. This combined approach of tough penalties and rigorous enforcement reinforces the socially unacceptability of drink and drug driving and reminds people of the very serious consequences. I'm seriously grateful to my honourable friend for bringing this debate. The ULS scheme is not shrouded in mystery, and nor should it be. But it is not often that we have the opportunity to debate the scheme in any detail, and I'm very grateful to him for providing that opportunity. I'm also grateful to his constituents, and I acknowledge their courage in allowing Charlotte's case to be highlighted. I know personally how difficult it is for family members to come to Parliament after such a tragic event, and I know the toll that even this debate will be taking. But as my honourable friend continues his campaign, it may be at the least a little comfort to know that Charlotte's tragic case will help. It will help to highlight the scourge of dangerous driving. It will help and has helped to make a difference, as my honourable friend has mentioned, and his campaign, and the increase in sentencing in the 2022 Act. And Charlotte's memory will continue to have a positive impact in the future.
The question is that this House do now adjourn. As many as are of that opinion say aye. Aye. The ayes have it. Order. Order.